Okay, abusuya for ebe mmakwa abashon so edeba POG Media so abusuya yembonra eye yensemu eye Chief Justice Torkornoo petition for the removal no abusuya back and forth ede ehon informations ebre na say ede ehon update ebre no emremu no e wo say a case be say ekoso a Chief Justice say petition be called na Chief Justice no or responded to the petition as a process no is ongoing. John Dramani Mahama and as a president of Ghana no or who can say or suspended a Chief Justice Torkornoo na we NSCC Chief Justice Torkornoo and no NHS project at your screen on China CC ye ba suspended no from a year Supreme Court to abusuya enye asem ketwa until right now no bibia da kwema process no say and cost no Chief Justice Torkornoo no say ye be suspend no every ne office and as every Supreme Court abusuya sisi ano eno no latest update yenso ye de bremo eno NHS ya project ade ato ye screen nche no abusuya yensa memremo yanko na yenkonko tie ensema e course na answer na ye be kono or and some time be a share comment section like na share ma afofron so answer into me and kabi aha POG Media so madam
has responded to a petition which seeks to remove her. Now her fate lies in the President and then the Council of State to deliberate on the matter and see whether it merits removal or the petition's merit for her removal or not. Let me start with you, Theophilus.
Good morning to your listeners again. I find it interesting that this whole process had to go back to the Chief Justice back to the President. In fact, there was a time a certain Supreme Court inserted or rewrote our Constitution to insert certain clauses that ask for the President to determine a prima facie case. Now, she's now submitted her response. The President must, as a matter of urgency, start to discuss with the Council of State to take the process to the next level. Now, I expect that this process will be quick because the uncertainty will not help the judicial delivery in this country. So, again, nobody knows what's in the petition. Nobody knows what's in the answer she has given. But we are all looking at the situation that is the answer going to be the one that will make the President say a prima facie case has been determined, or the President is going to say there's no prima facie case. Now, if the process goes very fast, depending on the advice from the Council of State, it's likely that the Chief Justice will be suspended. In fact, the whole Article 146 was very strict. There was no need for the Supreme Court to have inserted anything in it. So I expect that the process will be quite fast, and the committee will be formed. If there's need for the Chief Justice to be suspended whilst the work is done, that recommendation might come from the Council of State. If there was no need, the committee is formed. She's asked to present her side of her story or her defense. Indeed, God that we say knows everything. When he entered the Garden of Eden, still asked Adam, what did you do? So that's the bedrock of our constitutional democracy. The first rule of natural justice, her side will be heard. And this process should not take so long, so that the uncertainty or certainty that will hang over the Supreme Court will be quick. Remember, the Chief Justice is the administrative head of the judiciary. So if there is so much uncertainty, it trickles down to everybody. So I expect that this process will be quick and done with very fast.
Mr. Johnson.
Good morning to our viewers and listeners, my good counsel. It's a process. But Lily, remind me, what triggered this process? It was from some individuals, right?
Yeah.
And what was the reason given for them to get the President to remove the Chief Justice?
Well, that has not been made public because the previous one was made public. That was by Professor Kwasari. That was made public. He stated issues of of misconduct, right? But these are fee petitions submitted by private individuals. The details of the petition has not been known. We don't know what the stated petition involves.
Shouldn't they do that?
To make it public?
Yes. Are we not supposed to know? She's our Chief Justice. Separation of powers. And if she's done something wrong or ultra-virus to the law, should we not, the people, know the reason why it's being asked for her to be removed? I didn't feel comfortable with that, because as you're saying, we don't even know the reasons. So if we don't know the reasons, and it so happens that going through the process that my colleague has mentioned, goes to Council of State has a look at it, can even sometimes, after the Council of State has have a look at it, the President's own lawyers will also have a look at it. He would then have to decide whether there's a prima facie case against the Chief Justice. Then we'll have to decide whether, okay, I'll go according to Article, is it 146 to suspend her or to remove her. Then you ask the question, will the politics come in and play in there? Because she was put in power by one government, so I don't think I can work with her, so she should go. You know, all this. But we need to know the stated course for this process that is going on. I think it's imperative. And I read it, and I wasn't sure whether it had got to do with after the President had made his mind up. A 3-member committee is formed, isn't it?
That is so.
Once the President decides that there's a prima facie case.
5 members.
5 members. I thought I saw 3 here.
5 members,
okay.
Bill of 2 justices,
2 justices,
3 ordinary
okay.
people.
Okay.
Not lawyers, not MPs, not members of the Council of State.
Okay. The thing that, I don't want to use this word because I'm not sure whether it's the right word, but when you get onto the Council of State, there are eminent lawyers on the Council of State.
Retired judges,
Attorney General,
retired Chief Justice,
retired Chief Justice,
retired Speaker.
So I think, retired Speaker. I think the legal process would be really examined to what her response is and the reasons why they have brought this case against the Chief Justice. So let's see. I just hope the reasons don't turn political, because in the past we've seen such things being political decisions, and that the reasons would be told the people of Ghana once the decision is made. I think it's important. The President, in his, I'm not sure, State of the Nation address, indicated transparency.
Yeah, it was even in his inaugural speech.
Transparency to the people of Ghana. And I expect it to go through every chain, every line for the people to know. We have been kept in the dark on so many things in the past. I think we're getting to a point right now where the politics of Ghana has changed in terms of the people's knowledge of what politics is about, the people's knowledge of what they expect democracy to be. So I expect that the real reason is given why a certain line was taken, especially if a prima facie case has been identified. And let's see how it rolls. But please, both, majority and minority, don't let us play politics in Parliament. Let's go according to the content of the reasons why, both in terms of why it was brought against the Chief Justice and the reasons why the President made a decision the way he would make his decision.
To add to us, Senior, or to explain a few things, under Article 146 Clause 8, it says that all proceedings under this article shall be held in camera. And a certain panel of the Supreme Court previously held that in camera means even the content shouldn't be known. So
that's precedent.
They went on to say that having published the contents of the petition had already violated this part of the Constitution. So much as there may be merits in the petition, the violation of a constitutional provision has made it that the petition could not go forward. So in order, and if you read President Akuffo Addo's, former President Akuffo Addo's comments on Kwaku Azan's petition, this was also referenced to. So that is the more reason why, if you read President Mahama's letter to the current Chief Justice, he says that this is being transmitted to you under restricted level of security. So if the Chief Justice, in her own wisdom, decides to spill it to the public, so be it. That is her problem. But from the presidency, it is being said that we are sending it to you with shall be held in camera, to mean that let nobody knows the content. You see, Sina, you are aware that the modern purposive approach of constitutional interpretation sometimes even leads to absurdity.
Yes, it does.
It leads to absurdity. Certain things are very clear. You don't need to go for purposive interpretation for it. You just go for the words. The words are clear. In camera means when you're having the discussion, the hearing, it should be without the public.
Yes.
Finito.
Yes.
It doesn't mean when the petition is received, the receiver should also be in camera. It doesn't make sense.
You see, this is where, when you look at the 1992 Constitution, life has run faster than the Constitution. That's why the Constitutional Review Committee should look at this. Should look at this particular clause. Okay. I mean, shouldn't we know? I mean, why should it be everything in camera? The hearings might be in camera, but the results of the hearing, the reasons why you took that decision, it shouldn't be in camera.
And what initiated the whole thing should not be in camera.
It should be in camera.
We should know.
It should not be. We should know. Like the president sacking somebody and not giving reasons why. When you are appointing him, you gave reasons sometimes. So why, when you sack him,
you told us.
The people are the ones who put the politicians in power. They have kokromoti power, thumb power, and without that thumb power, the president will not be in power. The president will not be president.
Sure.
So if you have a maid, is she not under your control? Or is he not under, or a houseboy? He's not under your control. Isn't it what you do? That what you say is what he should do? And if the people have decided that you, Lily, we have voted you as president of this country, do they not deserve to know some of these things? I find it a bit, I will not use the word spurious, but I find it a bit, we have moved. Constitutional Review Committee, look at this clause. I think it's important.
Right. It's important that he says the Constitutional Review Committee will look at this particular clause in our 1992 Constitution. But don't you, Mr. Johnson, don't you think that it is a sensitive position that the Chief Justice holds? And so putting everything out in the public doesn't taste well.
I mean, the reasons why a certain decision was made. You don't think we should? You don't think we should know? I believe we should know, at least. Give us reasons why it was decided in a certain way. So, nobody knows. The president says, I cannot work with, the Chief Justice, there's a prima facie case, she's hauled out. Are you trying to tell me?
From the very first instance where government communication put out a circular that, petitions have been received at the presidency from 3 individuals, the content of the petition should have been circulated. Do you think so?
Well, what's the reason? Do you know the reason why?
No.
The reason could be as spurious as anything. The reason could be, she did this against this, she did this against this. That's why we are moving here. We don't know. But we've got to know. You don't think we should know?
We should. It's important.
We should know. It's important. Or politicians think that it can go against them in elections. Also, my baby we are there. Missing me we are there.
You gave me the opportunity to respond.
You don't want anybody to know what I've stolen. I think, for me, I think the Constitution is how many years old now? 30 years.
Over 30.
Certain things have gone forward. It should be updated to, it's a living document. Should be updated to take care of those things. I don't see why there should be secrecy. So the secrecy would do what? What will the secrecy do? It will harm somebody? It will harm somebody? What's the reason? And you see, this is Ghana. It will leak. And the challenge is that when it leaks, that is when people sit on media stations and then all sorts of things are banded around. Things that aren't in social media. Then the thing is made manya, but it could have been very simple. So, Constitutional Review Committee, let's look at that clause. I think it would help us. We're moving forward.
I know you want to say, but let me welcome Ishak. Ishak Ibrahim is a member of the NPP communications team. He's also a lecturer at the UPSC Law School. Good morning to you.
Yeah, good morning to you.
I trust you're doing well.
I'm doing quite great, thank you. And good morning to your viewers.
Right, you're welcome. We're talking about the Chief Justice.
Good morning to my very good friends.
Well, it's a panel of lawyers this morning.
Yes.
I'll take. He has a rebuttal, but I'll come to you so you have the bite at the CJ responding to petitions seeking her removal. Theophilus, you wanted to say something, then I can.
You see, let's break this down for the ordinary viewer to understand.
To understand, yeah.
There are various ways of interpreting a constitution or a document. One is the literalist approach, the way you see it directly as it is. Another one is the modern purposive approach. That is the one they are currently using. That is what is the purpose or the reasoning behind the clause in the constitution. Now, part of the clause says that when the president receives the petition, he shall refer it to the Council of State, and they shall, in consultation, determine whether there's a prima facie case. Now, the purpose of that, to me, is that, as Senior said, any frivolous petition received should not be sent to the Chief Justice. They look at it and say, come on, this doesn't meet any threshold. We've been it. But if we are now being forced to a situation where every petition has to be sent to the Chief Justice to respond before they determine the prima facie case has been made, it means that if there are 10 petitions in a day, 10 have to be sent to the Chief Justice for the Chief Justice to respond and bring it back. Now, will this response, for example, the current response for the Chief Justice, will it be different manifestly from the defense she's going to put up? I doubt. You are literally going to say almost everything you are going to rely on in your defense. Then the prima facie case is made, then you now open your defense. It doesn't work that way. In a trial, you are not supposed to say anything until the adversary says everything.
The burden is on the prosecutor.
The burden is on the one who is asserting to say that, hey, you've done A, B, C. Then you say, I haven't done anything. He hasn't met even this threshold. I don't have to talk. And they make a determination that you don't have to talk. In criminal case, that's what we call submission of no case. But now, you have submitted your case. Now to them, then they will look at it and say, hey, and I don't know, perhaps, what if the petitioners get copy of your answer now? If they get copy of your answer now, they will go back, look at their original charges. Exactly. Do further digging. So to me, this prima facie case and the insertion through purposive reasoning was needless. And I can't but agree with Senior that Constitutional Review Committee should look at it. But again, you see, the Supreme Court is a policy court. They can decide to make a man a woman tomorrow morning. And we all just have to say...
They are not held by their previous decisions.
At all. They are not bound by their previous decision. We all have to say, is the Supreme Court saying it? We just have to follow. We don't, as a matter of people in this country, subject Supreme Court rulings to public scrutiny, public lectures, dissect, give different opinions. You start to do it, and you are hauled before the General Legal Council that you are undermining the Supreme Court. But wait, before Roe versus Wade was made in the U.S., even that was leaked. It was discussed several days, several hours before the ruling or the judgment by the Supreme Court of the U.S. came out. But nobody was held in contempt. But you dare not do such a thing. Not the leakage, but when there's even a ruling, there's no way. You know that the current Attorney General has an issue with the General Legal Counsel because he made a comment. You know, there was a time GIMPA organized a program and Justice Atuguba outlined, not Justice Professor Atuguba outlined cases being won by the judges who were appointed by certain government, I guess, and it became a big issue. But those are things that we need to dissect. In certain jurisdiction, before you approach a court, you try to know the background of the judge, whether it's a naturalist, whether it's a religious activist. You try to know all that. But we don't do those things in Ghana. So hoping that even if the constitution is written as if it was written for a kindergarten pupil, I still think that some Supreme Court panel one day will make a policy decision out of it.
And these things help professors like Ishak when they are training lawyers. You know, they refer to these things and question it in the class. But just before Ishak comes in, I think the overall challenge is, should the president be the one to choose the Supreme Court judge? I think that's the overall challenge because of separation of powers. In the UK, it goes through a certain system and then it's recommended to the Prime Minister. And then Ishak, remind me, there's a body that looks at it.
The same Judicial Council, just like
yes.
They actually, they more or less
recommend everything. Recommendation,
which is binding on the Prime Minister.
Yes, binding on the Prime Minister.
Yes.
Maybe we should have a system like that, so that the politics is taken out.
These things should be imputed when the constitutional review.
Yes, they should look at it. I mean, separation of powers. We don't practice strict separation of powers, but there are certain things that the executive shouldn't get themselves involved in.
Okay. Ishak.
Yes, thank you very much. First of all, my apologies for not seizing the first opportunity to say hello to my seniors here. I was actually deeply enjoying your submission. It takes forever. Nevertheless.
Okay, Abusia Wene and Sama Ekoso, our political highway, so Chief Justice Torkornoo to be suspended. And all, and once some any of the Brahma, but I must say, Sir Maje Penny Cocotis are Odiwe, and my aha, POG Media, so, but I must say.